One of the things that I say about our Court of Appeals and our Supreme Court is they're very curious. They like to know exactly what happened and when. And if there's any question on appeal about what happened on a certain day, if there's an argument that something is missing from the record that would help shed light on what happened, your issue might not get considered. So one tip is just to make sure you get all those transcripts, not just the ones that touch on the issue that you think is the biggest appealable issue. Get them all if you possibly can and order them early.
This is Courtroom Stories and Tactics by RVA Trial Lawyers, hosted by Sharif Gray and Niall Abuzaki.
All right, we're back, RVA Trial Lawyers, and today we've got the pleasure of having Rachel Yates joining us. Now, before we get into who Rachel is, what Rachel does, and why you should listen to this podcast and call Rachel if you ever have an appellate issue. So I think I just gave a nice little teaser about what we're going to talk about. But the story is, so despite, I don't know. Well, I mean, you can probably tell. Like I'm short, small stature, may have been a wrestler.
The ears
give it away, but that's why I've got the headphones on right now so you can't see it. But Rachel's husband actually wrestled, and we back in the day, and we were all in the same group. If I remember correctly, we were probably both on Team Virginia at one point and probably went to the same training camp. So when Rachel and I met, I remember you mentioning, Rachel, like, hey, you know my husband, and you also know his brother, right? Like they wrestled at James River, and then she mentioned the name, so I was like, yeah, that all makes sense now. So it's amazing, truly, like how small of a world it is. Yes. And I mean, I think that's also a great analogy for kind of the legal world too. We know everybody, right? Like it's, especially if you're practicing here in Richmond or in Virginia. But anyways, without me going on and on about wrestling and all that, thank you for being here. Rachel works as an appellate attorney. She has her own firm, focuses exclusively on appellate work, criminal, civil. I know nothing about appellate work, and every time I even have to get close to appellate work, I close my eyes and run. And so super excited to have you because I know there's a lot of lessons that you can impart on us that will be helpful to us and our clients when we are in trial, and we do need to preserve the record, and when we do get a ruling that doesn't go our way, and ultimately need to engage someone like yourself for appellate work. So Rachel, thank you for being here. Why don't you take a minute or so and introduce yourself?
Sure. Well, first of all, thanks for having me. I always tell my clients I'm a little bit like the dentist. I'm the expert nobody wants, but when you need one, you want a really good one. And so I love what I do, and I'm lucky that I love something that a lot of people don't love, and I am aware of that. So that's why it's a special niche, kind of like wrestling. It's not for everyone, but those of us who do it and love it, we're so happy to have that. So a little bit about me. So I have a husband named Zach. He's pretty great. He and I met in college at UVA, and we've got 2 little boys. They are absolute psychopaths. I don't know how I ended up surrounded by boys in my house, but nevertheless, here I am, and it's very, very fun, very busy every day. I've got a famous dog, which is probably a story for a different podcast, but if you're a dog lover, I've got a very special giant Labradoodle who has graced the stages of Richmond in many a performance. And
oh, wow.
Yes, he was talent scouted. So he's much more important than I am in his segment of the world.
Actually, quick question for you. Does he have his own Instagram page?
He used to. Okay. So he's 13 and a half. He's about 100 pounds. So he is a senior citizen, but he is an actor. And he would tell you that if he could. So he just lives his best life now, getting spoiled. But that's about me. I love Richmond. I'm a Richmond transplant. I'm from the country originally.
So when Richmond transplant, were you a Richmond transplant prior to law school or?
Law school. And my husband's from Richmond. So he brought me here, and then I fell in love with it. So I'm from Franklin County, Virginia. So if there are any listeners who even know where Franklin County is, it's different than the city.
Will they be able to find it on a map? Maybe.
Yeah, it's beautiful. It's in the mountains. We got our first stoplight.
I know what Franklin County is too.
Remember when we got the Super Walmart? That was a big deal when I was a kid.
I remember when I was in the Army, and I did the reserves for a few years before I went on active duty, and we would have some drill weekends, right? And there were some guys from Franklin County, and
Good wrestlers.
well, not just good wrestlers, they also may or may not have been very talented at making this thing called moonshine too. And so there was the Franklin
exactly
County
right.
guys always had the moonshine. And what's crazy, not only were these soldiers, they were also law enforcement. So anyways,
It was the moonshine capital of the world at one point. That's a true fact.
I'm not surprised at all. I think there's even a TV show on it.
I'll tell you, hypothetically, we had someone work on our house once when I was a kid, and at Christmas he gave us gifts of moonshine, and that's Franklin County. It's a very nice place to visit, and good people.
No, I'm sure people are happy there all the time.
Hospitality, you get nice drinks and cocktails.
That's right. That's right. And, everyone's got clean radiators, right? So anyways, well, you didn't start off doing appellate work, right? I mean, my understanding is that you clerked and then you were a trial lawyer. Is that right?
That's right. I am an accidental appellate lawyer. I was an accidental trial lawyer, actually. I thought that I would never, ever be in a courtroom. I was someone who wanted to be a transactional lawyer. I'm a happy nerd. I like to be in the background. I don't necessarily like performances like my dog does. So I thought that that's what I would end up doing. And in law school, I don't know if you all were like this or if you knew all along this is what you wanted to do, but I was forced to do mock trial and trial advocacy by school. And then I realized I loved it. And I'm not a natural. I have to work really hard at the kind of things that some of you are probably just very good at naturally. But I found that I really liked the challenge of it. And so I loved being a trial lawyer. But we needed appellate help when I was at the public defender's office. That's where I started. And so I started to do just a little bit of appellate work. And I thought, ooh, I really like this. And so I started to do more and more and went to the Attorney General's office. And I was a prosecutor there for a bit with their Medicaid fraud unit and elder abuse section. And then I quickly went to the appeals section and just loved it. Great people, great experience. I learned so much. So,
what is it about appellate work that draws you to it?
I love learning, I think. And with appeals, it's much slower, right? In the trial court phase, it's so fast paced and you have to think on your feet and it's so quick and it's a completely different challenge and skill set. And then with appeals, it's that slow, quiet work and the research about something that maybe no one else has ever really thought to look at. There might be no case on something and your job is to find that out and then help make the law. And I think that is the coolest thing. So I just feel really lucky. Before we started, I had said, I really think that my job now is getting paid to learn in some ways. And so I just feel blessed to have happened my way into it. And then I saw an opening for an appellate firm and I thought, let's do it.
Yeah, there just aren't that many lawyers, period, that specialize in appellate work outside of your big firms, right? I mean, in Virginia, I only know a handful, and you're one of them.
Yeah, I think that's right. So with Appeal of Right, I know some of us know all about that and others maybe not so much, but the appellate landscape changed a lot in 2022. And there are a lot more appeals now than there used to be. And so I thought I would like to be one of those lawyers making use of this new business. And right now, I'm the only appellate law firm in Virginia. I had some colleagues who've since left the space. And so I've been really fortunate to be doing this work that I think is so interesting and that I love, but it's also hard. It's hard to be in your own small niche and forging your own path, but it's also a really fun challenge.
So what are some appeals of right? And then we'll get into at what part of the trial do you come in? Are you coming during the trial or you come in after a trial takes place? Because we can see your how you can help even at the trial phase. But let's first talk about appeal of right issues.
Yes. Okay, great point. So before 2022, there were certain appeals that everyone had a right to appeal based on. So criminal cases, for instance, you used to have to petition the Court of Appeals and say, my appeal has merit. Please, court, grant my appeal and hear my case. Now with Appeal of Right, everyone in Virginia virtually has this automatic right to go to the Court of Appeals. So not only does the Court of Appeals itself hear more cases, because they used to be a court of limited jurisdiction, they would only hear certain segments of appeals regardless. Many appeals went straight to the Supreme Court. Now the Court of Appeals is hearing virtually everything too. So it's good for me in that there are a lot more appeals because there's this intermediate appellate court and it's by right. There's no more petition. So if your client in a civil case wants to appeal, they now can appeal. They don't have to petition for the opportunity to appeal. They can go to the Court of Appeals and have their case heard.
And is that more standard? I mean, just in looking at like the federal framework, which a lot of law schools end up teaching, it's the district court, the circuit court, and then you do petition though for the U.S. Supreme Court. Is Virginia now follow that same model?
Yeah. So in Virginia now, it follows more like most other states. So most other states would say they have appeals of right in a similar way. And in Virginia, you still do need to petition the Supreme Court to hear your case, and they take very few of those, as we're all aware of probably. But the Court of Appeals is now hearing so many cases. So if you have a case and you have a client who desperately wants to appeal and they're not happy, or the other side wants to appeal and they're not happy, it's good to know everyone has the right to appeal now. So they can go straight to the Court of Appeals.
One of the things that I've always found daunting is the process in which to actually go about getting an appeal done. I mean, the procedures are fairly daunting in the sense that like the briefs have to be filed by such and such day, transcripts have to be done in certain ways, and I almost think like unless you specialize in this work, good luck. I mean, just you really need help just even getting to the merits.
And Rachel, it's important to break down. So let's say we have a trial. One of the parties is not happy with what happened in circuit court. Let's walk them through the process of appeal.
Sure. So let's say it's a civil appeal.
Okay.
So civil appeals are a little bit different. So the first thing that I would look at if someone came to me and let's say a judge issued a letter opinion and we weren't happy, or there's a jury verdict and we didn't like it, is there opportunity for a post-trial motion to try to make sure we're preserving all of our issues? If not, then what we do, the first thing, is file a notice of appeal. I think most of us are aware of that piece, but there's also something called an appeal bond. And there's a form, it's got to be notarized, you pay a certain fee. You do that at the same time. You have to file certain things in certain courts. You have to file all of the transcripts. So one tip that I would mention in this is to make sure you are ordering every transcript of every hearing that might conceivably touch on anything related to an appealable issue. So if you have a motion state, get the transcript for that. If you have a discovery dispute, get the transcript for that. I know clients don't want to pay, or if you're the one who's covering the cost for different reasons, it's tough, but you want to get that because one of the things that I say about our Court of Appeals and our Supreme Court is they're very curious. They like to know exactly what happened and when. And if there's any question on appeal about what happened on a certain day, if there's an argument that something is missing from the record that would help shed light on what happened, your issue might not get considered. So one tip is just to make sure you get all those transcripts, not just the ones that touch on the issue that you think is the biggest appealable issue. Get them all if you possibly can and order them early. You have to file those transcripts in the circuit court. You have to file a notice of filing transcripts. Honestly, it's very annoying. I wish it was an easier process, but it's a really important process. I call this the transition phase. It's the transition from the trial court to the appellate court.
What's the timeline?
It's quick. It's quick. As you all know, it takes a little bit of time after the bad verdict or maybe the good verdict for the other side or someone to start to think, okay, we're serious about this. What do we do next? So the initial notice of appeal and appeal bond are both due within 30 days of the date the judge signs that final order.
And what is an appeal bond?
So you pay a $500 check, but ultimately it's a form that's notarized, and it's a promise to abide by the terms of the judgment. Whatever it is the appellate courts do, you are promising and binding yourself and your clients to comply with whatever those directives are. So it's essentially a way to ensure historically that someone isn't appealing just to avoid complying with something. It's a promise that you're going to do what you need to do. The statute itself is very complicated. It's very confusing. There's been some work done to try to clean it up. The same thing with something called a suspension bond, if you all have heard of that. It's what you need and what you should consider doing if you want to pause the judgment from going into effect during the pendency of an appeal. So if your client is ordered to pay a judgment of some kind, or the other side is ordered to pay a judgment of some kind, if they don't post a suspension bond, then that judgment goes into effect 21 days after the final order is entered. So that's something to keep a lookout on. Just because the other side appeals, let's say, if they're not happy with something, if they don't post a suspension bond, you can immediately go after and enforce that judgment. So that's something to take a look at. Similarly, if your client's the one on the hook, talk to them about a suspension bond. Usually it needs to be the amount of the judgment plus interest, and it can be hard to get that amount depending on how much it is. It can be hard to get a company to post it for you. It's just complicated.
And that's what so when you're talking about an appeal bond, that's a fixed amount.
That's right.
A suspension bond typically is the judgment amount plus interest. However, you can also argue to the court to reduce it. Is that correct?
That's correct. There's some law that would say it has to be at least the amount of the judgment plus interest. But there's also a carve out in the statute. I think it's 801-676.1, and it says something to the effect of, for good cause shown, the circuit court can modify this. But there is at least some authority that would say it still needs to meet that minimum. So a lot of times where that good cause question comes in is there good cause to raise it? Or if it's not a money judgment, for instance, if it's something to order someone to do something, or it's something where there's not an obvious value attached to whatever it is, sometimes it's a good idea to ask the circuit court to set that suspension bond if it's remotely unclear, or there's a good reason to ask someone to change it. And again, as with many things, sometimes it's arguable. So sometimes it makes sense just to see what happens and let the other side poke at it if there's a good reason not to do it. So as an appellate lawyer, sometimes it's fun to play with that gray area and see what happens.
And who holds the money?
The circuit court clerk.
So 30 days to note an appeal within 30 days, and that's...
It's so quick.
Yeah.
It's so quick.
And from there, they noted their appeal, they ordered their transcripts. Mm-hmm. What's next?
So they need to file the transcripts within 60 days of that final order. And that can come quick too, because as many of us have experienced, some court reporters can be very protective of their time and their energy and the way that they work on these things. Some of them are really quick. Some of them want you to pay those rush fees if you need it quickly, and those can be pretty costly. So I encourage folks to do that as quickly as possible, is to get those orders in. And then they do have to be filed within 60 days. You can ask for an extension if you need one in the appellate court, which is a little bit confusing, even though you're filing it in the circuit court. So this is one of those things where I tell my trial lawyer friends, you can phone a friend. You can call me if you're in this weird nebulous space and you don't know what to do during this transition period. And I'm happy to walk you through it the best I can with your hypotheticals. And it is confusing. It's confusing even for appellate lawyers. I don't think anyone likes the transition phase between trial work and appellate work, but it's really important. If you make a mistake, it can tank your entire appeal. So it's one that's really important to get right.
We're 60 days out. What do you have to do to continue to effectuate the appeal and perfect it?
Okay, so your transcripts have been filed. You're going to file a notice of filing transcripts no later than 10 days from the date of your last transcript. But read the rule. It's Rule 5A:8 because there are always little exceptions and carve-outs.
And who's that filed with?
That's filed with the circuit court.
Okay.
So one thing I would note is court reporters. Sometimes clients want to avoid paying for a court reporter. And we all understand. Sometimes it's really hard to get them. I've had cases where there's an emergency injunction hearing, let's say, scheduled for the next day. No one could get a court reporter. That's no one's fault. Sometimes it just happens. But to the extent it's possible to get a court reporter, please get a court reporter. And here's why. Because if we don't have a transcript from a certain date and it's impossible to order one, you're stuck with something called a statement of fact. And they're terrible. And it's virtually impossible to do well. If I'm on the other side of an appeal and someone has filed a statement of fact, I will do everything I can to get your appeal thrown out. Because if I can make an argument that that statement of fact is not as well done as a transcript would be and doesn't show everything that the appellate court needs for it to decide, was there a procedural default? Were these arguments actually the same as the ones being made on appeal? I'm going to make that argument. And you should too, if you're the one advocating for someone and there's a statement of fact on the other side. And those are also hard to get right. There's a lot of rules. So that's my pitch to you. Tell the client if they're complaining, the mean appellate lawyer says you have to get a court reporter and we cannot do a statement of fact. So that's my pitch.
In the statement of fact, if I recall correctly, if both parties agree to the facts, then the issue is just on the law, then that will be the statement of facts of what unfolded in trial court, correct?
That's right, but the appellate court doesn't have to accept that that's complete enough. Yeah. And that's the hard part, because sometimes the lawyers are very reasonable and know what happened and everyone's content and happy because they were there and they know this is an accurate reflection of this and I'm not concerned about this. But sometimes the appellate courts are the ones who are persnickety. And that makes it really challenging and a little bit unfair, because sometimes you think, well, if we agree, what's the holdup? No one's making a procedural default argument. So why is the appellate court so concerned about this? So just know sometimes they are persnickety.
You
heard it from me.
We're not even at the merits yet. We're still in the transition phase. So what happens after this?
Then, if you're lucky, the circuit court clerk does everything correctly, compiles all of the documents, everything in the judge's file, all of the transcripts, and sends them up in one beautiful electronic package to the Court of Appeals. And you, as the lawyer, counsel of record, will get a link to a box, an electronic box, and can download the entire record. That's usually done 90 days after the final order is entered. But some clerks' offices are a little bit quicker. They can be quick on the draw and throw off your deadlines, or some of them are a little bit slower, and that can throw off your deadlines. So what I do and what I tell folks is calendar 90 days after the final order is entered. That's a good benchmark to at least anticipate that's when your appeal might really begin. The reason that date is important is not just because you finally get the record that you're going to be working with, but it's where it triggers your true appellate deadlines. Your briefing schedule, where you have to decide what your issues will be, called a statement of assignment of error. And so the date that that record is sent to the Court of Appeals, not necessarily the date the Court of Appeals sends the record to you. Warning, sometimes those dates are different. That's what determines all of your future deadlines. So it's really tricky, but if you're a rules person, if you like knowing the rules and understanding this is the cadence and this will happen and this will happen and this will happen, you'll like appeals. If you hate that and think that sounds very technical and stressful, well, now you have a friend to phone and I'm happy to help.
Now, do you, in your firm, do you guys get involved in the transition phase, or do you wait until the record's been transmitted and all that stuff and then?
Yes, great question. I do everything I can to avoid noting my appearance in the circuit court, because sometimes things blow up and then things get sent back to the circuit court. And so my strong preference is to simply stay in the background and advise my trial lawyer friends on what to do and how to do this. And I have forms. I will even draft these things, but I don't like to be counsel of record if I can avoid it, in case there is, for instance, a hearing on the statement of fact someone is trying to draft. If I wasn't there, I can't really represent, is this an accurate statement of fact or not? And if I've just noted my appearance as counsel, I don't like to obligate myself to need to go to those things. So that's my preference, but I'm a sucker. I frequently get called to help in the transition phase, and so I do. So I can do that for clients. I can be the one to do all of it. But when I have trial lawyers who I'm partnering with for this, then I'm happy just to help them and tell them what to do and guide them through the process so that they're not stressed. And they're the locals. They know what the circuit court likes and what the circuit court doesn't like in terms of the clerk's office. And if we do need to schedule a statement of facts hearing, anything like that. And so my preference is to just work with my co-counsel on that piece.
And at what point does the actual substantive work start then?
I generally start when that box link is sent to me, because that's when I have all the information. If I'm brought into a case earlier, and I think you had mentioned, well, how soon can you start working on a case as appellate counsel? I can start before the case is even filed. I was retained in one case with a colleague who was planning on filing a lawsuit, and he wants to overturn certain precedent on behalf of his client. They understand it's going to be a long shot, but with the understanding that this is the goal, they wanted help drafting the complaint, making sure everything we're asking for is exactly what we need to fit into this perfect band of cases to try to do this. So when I'm working at the trial court level and I'm working early on and something like that, I call it consulting work, where I just consult and I'll just help. So if someone wants to know, do we think this issue is preserved? Is this motion good enough to be able to argue X? I can look at that and give you some good feedback and say, okay, this is how I would analyze this if I were an appellate judge. I would look at this. The other side did this. What did the circuit court judge specifically say? Ultimately, on appeal, when I'm the party appealing, I think about a rule called Rule 5A:18. And that's the rule that says you have to make essentially the same argument on appeal as you did at the trial court. And you have to make an objection or an argument with reasonable certainty. That's the quote, reasonable certainty. So I can help make sure this was an argument that was made with reasonable certainty. And I can help say, did the trial judge rule on this in the way that we need them to? And there's a third piece to this preservation puzzle. So you need your objection, you need your ruling. The last piece of this is sometimes a proffer. And I think that word is thrown out a lot, and it's very confusing, and it can be challenging when you're in the midst of trial to have to do everything right. And please know that I've been there. I've been the trial lawyer who walked back to my office afterwards and thought, oh, I don't know if I did that right. I don't know if this was enough. And so I understand. So what my goal is as an appellate lawyer when I'm working on the front end is just to empower everyone I work with so they feel confident in knowing, okay, I think we did this. I think this was enough. This is a decent appealable issue. I feel good about what I need to do next time something problematic happens. And so proffer is this last piece that I mentioned, and that's basically setting it up so that the appellate court understands what it was that happened. So it comes up when evidence is excluded. So probably all of us have had evidence kept out that we thought should have come in. And so what do you do when that happens? Well, the appellate court can't see what it was that was actually kept out. Was it a written document? Was it witness testimony? What was it that was kept out? So we have to do something called a proffer to make sure the record reflects what that material actually was and why it's important. So it's important both to show it was actually admissible and also to be able to show this was critical to the trial. This was not harmless error if it was kept out. This is harmful error. This was impactful. So There are a couple things you could do. I don't want to bore everyone about this, but I love proffers and I love procedural default. So I could talk about these things all day.
Well, and this is something that's directly applicable to trial lawyers, right? Like, because we're in the heat of the moment. We're fighting over a piece of evidence. Judge says it's either coming in adverse to us or something we wanted to put in is not coming in. And so that's when the proffer applies, right?
Exactly.
Rachel, that's probably the most important part of trial work if you're trying to preserve an issue for appeal. And many trial attorneys fail to flush out the issue on the record. Before we get into the proffer, because I do want you to flush that out for trial attorneys. You file your pretrial motions, you highlight the issue to the court. But not only do you highlight the issue, you also have to make sure that the judge actually rules on that issue. So let's talk about that, because often if there's an issue before the court and if the court can circumvent it, will they circumvent it? And have you seen the issues being circumvented and therefore that it wasn't preserved because the judge didn't actually rule on the issue itself that they're trying to make a record of?
Yes. Okay. How many of us have had a judge say something like, we'll take that up at the appropriate time? And then you think, sure, wait, when is the appropriate time? I thought it was now. When is the appropriate time? So one of the things I used to do, and this is what I recommend to folks, is at the top of your notebook, or make this a second chair task. This is a perfect second chair task. If a judge doesn't rule on something you've asked them to, have them make a note of it so that you know to come back to it later if it's something that can be taken up later. So for instance, if this was a pretrial motion, if this was a motion in limine and the judge says, we'll take that up at trial, you have to remember to take it up at trial. And it sounds so easy on paper, but I've been there and I know, because when a judge uses a certain tone, when they look at you a certain way, everyone in the courtroom knows exactly what the judge thinks about the motion that you've just made. And you know, oh, the judge didn't like that. Okay. So it's easy to start to think, well, the judge said no. And you don't realize that the record doesn't reflect that tone, that facial expression, the feeling that everyone in that courtroom had that the judge didn't like that and wasn't going to rule in your favor. So one critical piece of preservation is to make sure you actually do get that ruling. Another thing that comes up a lot is if you make multiple objections at once. So if you say objection hearsay, objection foundation, and the judge says, well, was that hearsay? Well, let me think. I don't think it was offered for the truth of the matter, and everyone moves on. Well, what about that foundation objection? Did the judge rule on that? No. Everyone got lost in the hearsay objection because it was interesting and debatable and nobody knows. So one thing you can do, even if you think this is going to annoy everyone because it's so obvious, is just say, to clarify for the record, because the mean appellate lawyer made us. Clarify for the record, Your Honor, you're overruling both of my objections. The judge will say, duh, in a professional way. But on the record, it's really important to have that duh moment, because otherwise on appeal, we'll say you waived it. There were two independent bases for the judge to admit this. You objected to this one. You waived your opportunity on the other. So it's hard.
So the judge overruled your objection. Mm-hmm. You clarified that the judge overruled both objections.
Yes.
Now, as the party that objected, what should you do to preserve the issue on a record? Proffer on the record, what would the evidence be? And proffer on the record, if it's hearsay, if there's an exception to it. So Let's go through that.
Yes, absolutely. Okay. So if you take away nothing else from this podcast today, what I want everyone to remember is not to forget to proffer. And there are different ways to do this successfully, and it depends on what the evidence is a little bit. So let's say it's witness testimony. If you have an expert you really want to testify and the judge says no, or if the other side had an expert and the judge refused to let them, you can keep a lookout to see if they adequately proffer something so you can argue about this later on. But if that happens, the proffer's purpose, of course, is those two things we mentioned earlier. It's to help the appellate court understand what it is we're actually arguing about so they can independently examine it. And it's also to show that it was really important to your issue. So if it's witness testimony, the best and most ideal thing to do is to ask the judge to put the witness on the stand with the court reporter outside the presence of the jury, if there's a jury, and to call that witness and to ask them the questions you would have asked them. There's a lot of reasons for that, but the biggest piece is just to say, this is exactly what the person would have said had I been permitted to call them. Sometimes judges maybe don't want to let you do that. Maybe it feels awkward. You're in the midst of this jury. What do? Do you stop proceedings now? You're in a really good flow. Otherwise, what happens? As long as you do that, as long as you make this proffer while you're still putting on evidence, it doesn't have to be right in that moment. You could say something to the effect of, Judge, may I make a proffer at the appropriate time, maybe on the next recess? And the judge should say yes. So then you think to yourself, well, what happens if the judge says no? You can't make your proffer. That's a great appeal issue. There have actually been appeals about that exact scenario. If the judge tells you no, you cannot make your proffer, and let's say you're doing this at an actual appropriate time, you say, Judge, I have the right to make a proffer. I have a right to make my record. I object. And if the judge doesn't permit you to do that, that is a winning appeal issue. So that's thing one. Mm-hmm.
What case, Duchess, do you have a case in mind?
Oh, yes. Okay, so next time you're prepping for a big trial, you want to get ready about how to make your proffer. I think Welsh versus Commonwealth. It was a Supreme Court case from this year. I think it was the spring. And it outlines why proffers are important, how to make a proffer in an ideal world. There are different ways to do it, but that's the preferred way. So just think about next time, especially if you know in advance, ooh, this is going to be contentious. I don't know if I'm going to get this in or not. Think about how you would make your proffer.
And Paul, just continue. I interrupted. You were going to this second. So you make your proffer on the record. If it's a witness, you put the witness on under oath, ask questions, preserve it on the record, and then argue why that witness's testimony should have been allowed.
Exactly.
Now let's move to other evidence.
Yeah. So let's say it's a document. The judge says, no, you can't introduce it. You want to say, Judge, may I proffer this for the record? This would have been, X. Put it into the record. Then the appellate court can look at this excluded evidence and see, oh, this should have been admitted. And wow, this has really important stuff in here. I really wish I could have considered this. Maybe this truly was error. So you need to make sure that you actually furnish for the record whatever it is an appellate judge might need. Because you have to remember, they're looking at this from a dry written transcript. So they can't see what it is we're all talking about. So anything you can do to flesh that out is really important.
Is that where the whole notion of I'm marking this exhibit for purposes of identification comes from, right?
Yes, exactly. Same kind of thing. And one thing that comes up a lot, this is another good tip, is thinking about in advance how you're going to describe what witnesses are looking at when they're on the stand. So for instance, let's say it's digital evidence, right? There's a video on the screen. Everyone in the courtroom is looking at this video, and you're asking a witness to describe X, Y, or Z that they're seeing and why it's important. And you're pressing play and pause, and you're going through, and everything is smooth and beautiful. The problem is on appeal, we have no idea what it was anyone was looking at a certain time. Even if that digital evidence is admitted, we don't know. So the pro tip I give everyone is to think about in advance how you're going to do this in a way that's smooth and sounds good. But it can be something like, Mr. Gray, I see for the record, we're looking at 2 minutes, 47 seconds into this video. What are you looking at right now? And that way we on appeal can go, oh, okay, 2 minutes, 47 seconds into this video. I'm going to fast forward. And no one cares about Rachel. That's fine. You don't have to worry about making it easier for me to find. You have to care about making it easy for the Court of Appeals to find.
But why don't we just videotape everything? I mean, I actually, it's funny you mentioned this. Hell, we're videotaping this podcast, right? Like, it'd be so much easier. I remember in the Army how much of a tension there was between advocacy and preserving the record. So, for example, if you wanted to demonstrate something with your hands, the judges sometimes would stop us and say, well, please describe for the record how you're moving your hands, Mr. Witness. And it's to the point where it's like, it's ridiculous, right? Because it interrupts the flow. It almost limits your ability to do things as trial lawyers that are effective. And we talked about it voir dire to verdict. It's not just the words we use. It's our posture. It's how we move about the courtroom. It's how we interact with the jury. There's all those things which you can't see on paper.
Yes, it's so interesting. So one thing is there was a Supreme Court case recently, the past month or so, and it was about a contempt finding. And the Supreme Court ultimately was analyzing whether this person really exhibited contemptuous behavior, et cetera. Should it have been summary contempt? Should it not?
Was it in front of the court? Was it outside the presence of the judge?
Exactly.
Yes.
So what's important about it is someone had put into the record the video from the courtroom. So the Supreme Court was able to also see what it was that was happening. And this is one of those rare instances where the Supreme Court says the fact finder got it wrong. This witness didn't actually do what the fact finder said that the witness did on the stand. The fact finder had said, well, the witness was doing X, Y, and Z, and et cetera, et cetera. And the Supreme Court said, no, they didn't. It's a fractured opinion. The majority found that there wasn't sufficient evidence of summary contempt, and so it reversed. So that's rare, but I thought that was really good advocacy that someone thought to include in the record. This courtroom video, and practically speaking, I don't know what hoops they jumped through to get it. It was an interesting case because the Commonwealth had also actually agreed that this person should not have been found guilty of contempt. So it was an interesting procedural issue.
Might have the judge had it out for somebody there, right?
I'll stay quiet on that one. And it's
violate my order. Get back to there.
Sharif made a great point in regards to and it makes sense. Of course, it's not something that's in practice. Why not just video record the whole entire trial? I'll tell you, when I taken myself back to law school, when we're talking about wills and trusts. And wills and trusts, the issues come to light after someone dies.
Right.
And then now it's, hey, what was their intent? What really did they intend with this will? And in my mind, I'm like, why doesn't every wills and trust attorney just record?
Yes.
Not only audio record, but visually record the making of a will and or a trust, right? To at least get an appreciation. It may not resolve every issue for you, but it will resolve the majority of issues.
Yes. And what about AI? I mean, court reporters will hate this podcast recording, but the reality is if we have a recording of what happened in this courtroom, or we even have an audio recording, aren't there better and cheaper tools we could use to instantly transcribe everything that would be so much more efficient for our clients in the court process than waiting weeks and weeks for someone to put pen to paper?
Well, efficiency is not a goal of the Virginia court system because we still mail all our pleadings, right? Which is insanity. So
yes,
I'll also not touch on that, but Rachel, yeah, as you were talking about the statement of fact, when I used to prosecute, I even at preliminary hearings and even at trials, I used to ask for permission to record everything on my phone.
Yes.
It doesn't matter whether I believe that the defendant was going to testify or not testify. I always did that. And you're right. Something may happen. What if and they're in Henrico County Circuit Court, they don't have a court reporter, but they have a recording, and you actually clerk there. Mm-hmm. And the question is, well, what if the recording doesn't pick up what happened that day?
Right.
So you always got to have, and that's, for example, in Hanover, no, they have a court reporter. They record and they have a court reporter. Mm-hmm. But in Henrico, we don't, and thankfully it hasn't been an issue, but that can be an issue.
There are so many terrible things that could happen at any given day. And yes, there are many things that are on my list of nightmares. I've currently, want to say battling a court reporter, but I'm having strong words with a court reporter who was refusing to transcribe a proceeding that she covered because she was upset with a client, and so that's not an option. There's a code section that actually covers this precise scenario. We are willing to pay you, but we need you to do it. And so terrible things happen all the time. And the only thing we can do is just try our best to figure out what's reasonable under the circumstances to get right. And phone a friend if you need to, because two eyes are always better than one.
And they're busy.
It's hard.
Court reporters are busy.
Yes.
There are times when you call and you're like, hey, I want a court reporter. And
yes.
No availability for months on. And you're
Well,
like,
especially if you're not in kind of Richmond or another kind of metro area, right? I mean, we've had
That's right.
cases out in the western part of Virginia, and we need a court reporter, and it's good luck.
Franklin?
Not Franklin.
That's right.
Well, yeah, not Franklin. Not yet. That was good. That was very, very well done. But I mean, I don't know. The video thing, to me, it's common sense. I mean, when we depose people, I mean, and we're even starting now when our clients even get deposed, we insist on video. It's just because it makes it so much easier. From an advocacy perspective, I now get video clips that I could use at trial or through negotiations or mediations, which we don't do much of, but occasionally. But also, what makes it really easy is, all of us know that at the end of the deposition, we tell the person who's deposed, well, you've got the right to read through and correct any errors, or you can waive that right. When it's video, that's an easy conversation. Mm-hmm. You can waive it because if there's any issues, we just turn on the video camera, right? And so, but anyway, so I vote if I was king for a day, I would have video of everything. But then, of course, who knows? AI, you can probably create your own videos and stuff. So I'm sure that's going to hit
So
soon.
true.
You know what? You can just put the transcript and AI will create you a video of the whole entire trial.
That's right.
Yeah,
and I bet we could probably find a way to do that now, which is insanity, right?
Mm-hmm.
But no, this is fun stuff. Well, let's talk about, I mean, we've gone through the appellate process. We haven't actually hit the actual fun stuff.
The actual real appeal yet.
Yeah, we're getting there.
Let's do that real quick. But then I don't want to forget, I want to ask you, I mean, obviously you've been doing this work for a long time. Mm-hmm. There has to be appeals that have stood out to you, that have been meaningful to you. And I want to certainly to hear about those. But before we get there, would you mind just running us through kind of the procedural process for the actual appeal now that it seems like we're actually out of the transition phase?
Finally at the Court of Appeals.
Yes, my favorite piece. So the biggest part of an appeal is the brief. And sometimes clients are surprised by that because maybe they think it's the oral argument. That's the courtroom moment.
And Rachel, I don't want to know, did you just say that's your favorite piece?
Yes.
Yeah, you're made for this. Keep going.
That's right. You either love it or you hate it. And I am in the love it category. There is no better day for me if I have a hot cup of coffee. I'm sitting quietly at my desk. I don't have any meetings for a couple of hours, and I just get to nerd out for a little bit. It's
my nightmare.
Let's talk about your labor of love. I'm glad it's yours.
yes. Well, I feel the same way about other things. I'm so amazed by what you all are able to do and do it so quickly and all of the hard pieces with trials. So I think we all have our wheelhouses of the things we love, and I'm happy to go to the experts for those pieces as well. But I love it. So we start with the brief. The brief is the biggest piece. To do a good job with that requires a little bit of work. Obviously, research. But one thing I would also flag for everyone is reviewing the record. And it's easier for me because I'm coming at it with fresh eyes. So it's easy for me to identify that something's missing because I'm following everything carefully because I haven't seen it or read it or heard it before. But when you're a trial counsel and you have an appeal and suddenly it's in the Court of Appeals, check to make sure that everything in that record actually was sent up like it was supposed to be. I had an appeal recently where everyone used trial binders and everything was agreed. The exhibits were all agreed. Both sides were very collegial and reasonable, and they had planned this in advance. So the trial judge was a retired substitute judge, and he was sitting, and he had this binder, and the record did not reflect what was actually in it. Everyone just gave this judge, this kind, nice substitute retired judge, this binder with their precious evidence. And then he took it and he wrote his letter opinion. And I don't know where he was when he wrote it, but when the record was later sent up, it did not have the binder in it. So we had to chase down the binder. And there's a particular method to that. It's called a petition for writ of certiorari that you have to file in the Court of Appeals. They have to agree to transmit this missing piece of the record up. But then there was a missing piece of it. There was something the trial judge had referenced in his letter opinion. So we knew he had it. Both parties agreed it was in the record, but it was nowhere to be found. And troublesome things like that can happen. So be very, very careful when you are reviewing your record to make sure nothing important is missing, because it's really easy for things to go wrong there. So review your record, choose your issues carefully. That's something else I wanted to flag. So on appeal, it's easy for clients especially to think, let's raise absolutely everything. I didn't like this. I didn't like this. I'm unhappy about this. And what about this? And the same thing, when we're the lawyers who are in the midst of it, maybe we feel passionately about something because it just felt so unfair and we know the judge was wrong. But as an appellate lawyer, I might say, but that's probably going to be deemed harmless error. Yes, you were right and the judge was wrong. But did that impact anything in any meaningful way? Maybe not. So the second thing we're going to do after we review the record and we do some research is try and decide what are our best appeal issues. So we start with, okay, well, what did everyone argue about at trial? Obviously. From there, we say, well, what's preserved though? Because as you've heard by now, that's a different question. Did everything carefully get fleshed out and the judge actually rule on it? Did we make our proffers? So from there, maybe we have a list of 4 or 5 things. I will not do an appeal with more than 3 issues in an assignment of error. And it's really counterintuitive sometimes for clients who think, well, what's the harm in just raising everything we think was problematic? But that signals to the Court of Appeals or to the Supreme Court that you're not confident about your good issues and that you're just throwing everything out there. So then the court goes from saying, well, this does seem like a problem. Wow, this is really important and serious. Well, this isn't. I don't know. That's arguable. I'm not sure about that one. Ooh, this is a bad issue. I don't know why they even flag that. Oh, they don't know what they're doing. So even if you think there are 5 good issues, narrow them down to your top 3. And there are ways that I do that. I do it by looking at research. How right are we? How confident are we that we were actually the ones who got the law right? Secondly, what's the standard of review? So on appeal, appellate courts analyze issues differently based on what they are. Is it a factual question? That's tougher on appeal because, as we all know, judges get to be the fact finders in the trial court, not on appeal. So it's harder. Is it an abuse of discretion standard? Something like sentencing. There's a wide range. And if it's in this range, it's very hard to overturn something like that. So those are worse standards of review. Good standards of review, good appealable issues are legal questions. Anything where we can say it's a de novo standard of review, that's a good legal issue. That's something we really want to take a close look at on appeal. One of the other things we look at is that harmless error analysis we mentioned before. Did this have a meaningful impact at trial or not? If the judge misspells someone's name, well, maybe they got it wrong. That's error. Doesn't matter. Absolutely not. Did the judge exclude this really important expert witness? Yes, they did. That's a problem. That had a big impact in this case because maybe there's dueling experts and one was excluded. So we use all of these different factors to decide what are our best issues, and then we narrow those down. Then we do our brief. And we have targeted issues like we've just talked about. So the court knows to take it seriously that we're only going to raise issues we feel strongly about and think we might have a chance of success on. It's better to have one good issue than one good issue and one bad issue. It just makes the courts understand that this is really serious and you understand what you're doing.
And when we get to harmless error, just want to flush that out. You got to find the error first. The error is there.
Yeah.
And everyone agrees, or the court agrees, that the Court of Appeals, that there is an error and it should have been done differently. However, then you argue that even though there was an error, it's harmless given all the totality of the circumstances and the evidence that was presented.
Right. Right. And there's a different standard for constitutional error. Someone's constitutional rights were violated than if it's a non-constitutional issue where there was a problem. But here's the other hard part about appeals. Sometimes the appellate courts will say, without deciding whether or not there was error. In any event, this is harmless error. Assuming without deciding. Has anyone read opinions like that where you think, oh, I just wanted the court to analyze this so I can show everyone I was right. Even if it was harmless error, I was right. So it can be really frustrating to get an opinion like that.
It's like the qualified immunity analysis as well, right?
Yes.
Which is very frustrating.
It's so rough, and that's...
You're familiar with that?
I am familiar with that, yeah. No, I think it's wrong. Because one of the issues, right, and I'm sure the same issue goes with those types of situations, is you lack then a body of case law that dictates what is error and what error is not, right? And so when the court doesn't actually make decisions.
Yeah, sometimes we need the court to actually analyze something. Sometimes, too, if all of the cases say something like assuming without deciding, et cetera, et cetera, et cetera, it makes people think, well, I can do this and get away with it, even if it was erroneous. Not that judges tend to think that, but maybe opposing counsel thinks.
Yeah, there's really no teeth, right?
Yeah.
So you have your brief, top 3 issues if you have 3 assignments of errors. You submit it. There is then the other party gets the opportunity to submit their answer.
That's right.
From there, you get the opportunity as well to respond to that.
Yes.
And then the court rules after oral arguments.
Yes, with a few asterisks. So replies are optional, right? But always file your reply brief. It's very easy to say, well, the other side said something crazy, or I don't need to respond to that, or I'm really busy. Maybe the client doesn't want to pay for it. There are lots of reasons why folks don't want to file a reply brief. But I'll tell you, I was on a panel with a Court of Appeals judge last spring, and the judge specifically said, if someone doesn't file a reply brief in the Court of Appeals, I look at that as almost as if you're conceding the issue. Not technically, but that judge seems to think you must not have a good response if you don't file a reply. So always file a reply brief, even if it's quick, even if you're just hitting on the biggest, most important points, even if you only have 2 hours, file something. It's really important to do that. And then you're exactly right. The court will look over the issues. They might schedule oral argument. They might just issue an opinion. The rules changed this summer for when the Court of Appeals can avoid oral argument. And if it would not aid the decision-making process, the Court of Appeals can decide it will not have oral argument. And so word on the street in the appellate world is that the judges don't intend to invoke that much in counsel-filed cases or cases where any of us wouldn't be involved in something and there's meritorious issues, et cetera, et cetera. But the rule is a little bit broader than that. So we're all curious to see how this plays out long term.
Let's say the court does not rule in your favor. What are your options in the Court of Appeals before you then appeal to the Virginia Supreme Court?
Yeah, there's a lot of strategy there because you can do a couple different things. You can petition for rehearing before the same panel. Maybe you think, ooh, the Court of Appeals opinion mentioned this case. That case was overturned. I must not have realized that. There's this really good reason where I really need this specific panel to see something and argue something. Or you can petition for rehearing en banc, which is asking the full Court of Appeals to decide to take your case and analyze the issue. It's rare that the Court of Appeals will take a case en banc. It's rare that you will be successful if you file a petition for rehearing, but sometimes you want to do that, even if you think it's unlikely that I'll persuade this same panel of judges to change their mind. For instance, if you were the appellee, so you were the party who won, and you were in the Court of Appeals, and suddenly the Court of Appeals reverses, that sometimes creates a need for you to preserve something as the appellate lawyer in the Court of Appeals. So if the Court of Appeals does something unexpected, maybe neither party asked the court to do X or Y, and suddenly the court relies on X or Y to issue its decision. Well, that wasn't briefed. It wasn't argued, kind of came out of nowhere. You might need to preserve that issue before the Court of Appeals, meaning bringing it to their attention and getting a ruling in order to appeal to the Supreme Court next. So even if you think you're unlikely to succeed, sometimes in limited situations, you might really need to petition for rehearing. And once you get that denial, you can then appeal to the Supreme Court. But what's hard about that is you don't know when the Court of Appeals is going to issue its decision. For any of you all who have had one recently, you know it might be a long time after oral argument before you get your decision. And once they do, you only have 14 days to file your petition for rehearing if that's what you choose to do. So it can be fast and furious and really tough, especially if there's a new issue that maybe wasn't fully fleshed out before, and suddenly you have to scramble to address it, get the client to pay, do whatever it is you need to do. That's tough. The next option, though, is going before the Supreme Court of Virginia. So you have 30 days to note your appeal. And this is important because this can throw people off. The same deadline, 30 days, is what you also have to file your petition, your brief. So you only have 30 days to do that. Unlike in the Court of Appeals, where you file your notice of appeal, you have all this time to create your brief. In the Supreme Court, it's all due at once, and it's only 30 days. So it's hard.
Rachel, you took me back to Virginia procedure at George Mason Law School, now Antonin Scalia School of Law, when I took a class with Professor Costello.
Okay.
And, now it's all coming back, and all thanks to you.
Yes. Some of us love Virginia procedure. It's a joy.
Right. And I have to admit, I did enjoy it greatly then. So Sharif brought up, there has to be a case that stands out to you, an appeal that stands out. So thinking back on your career, what appeal just stands out among the rest?
Yeah. What's hard is, I don't know if you all feel this way too, but I don't tend to remember my wins. I remember my losses. Those ones where you think, oh, that hurt.
We hear that often.
Yes. Sometimes it's because it was unexpected. Maybe you didn't see it coming. And there have been a few where you see it coming and you know it's coming, and that doesn't hurt quite as much. But some of them, you put your heart and your soul into it, and then something happens and you think, ouch, I really think this was wrong. Other times you walk away thinking, I could have done a better job. I think if I had done X, Y, or Z differently, maybe that would have changed something. And I think this is true of my trial work too, so I imagine maybe some of you feel this way also, but you have a split-second moment to decide, am I going to do X or Y? And you walk away and you think, I think I chose the wrong one. I think I should have done this. So I had a case not too long ago where in a hypothetical, I don't think I answered it correctly. I think I could have given a better answer. And I dwell on those kinds of things. Oh, I wish I'd said this. Or in the moment, I said, good question to the Court of Appeals. Never say that to an appellate judge in the midst of oral argument. But I genuinely thought, oh, good question. And that's what we would say in our ordinary life. If someone asked us something unexpected and we were surprised and thought, oh, that's a valid point. Let me think about that. But you never want to say that at oral argument. So it was a moment that made me think, oh, I felt like such a novice when I said that. I know better and I still said it. Man, that's embarrassing. Oh, I hate that. And I dwell on those things. And I'm sure many of us recovering perfectionists feel that way about every misstep. We just think about it. Typos in briefs. I don't want to say I lose sleep about it because that would be embarrassing in itself, but sometimes I actually do. Sometimes I get, and all of us do, we care so much about the work that we do. And when we know we could do better, it hurts not to have done better. But I have a lot of those kinds of cases.
Well, we all do, right? I mean, every day. That's life. That's why they call it the practice of law. That's why, that's
the learning process.
We're human, right? We can't be perfect. But
yes.
Tell us about that. I'm sure there's a time or two where you got a good result on appeal and you got to pick up the phone and call that trial or call that client and say, hey, let me share what happened with the Court of Appeals.
One of the best things about being in practice for myself is I get to decide which cases I take, which cases I don't. And I had someone approach me who was adopting a child. And the child, their biological parent was having their rights terminated so they could adopt them. And the adopting parent was of humble origins, didn't have a lot of money, was very, very nice. We'd had this consultation. And I just thought, I want to do this one pro bono. I want to help this adoption. And so I did. And we were able to get a great result for the client on appeal. the other side's brief was procedurally defaulted. There are all kinds of technical things wrong with it. But the end result was just that feeling that what we do is so important. And sometimes it's important because we're creating the law, or we're changing the law, or we're doing something nerdy and academic and exciting in that way. And sometimes it's because we're genuinely helping people, and you just get to feel those good vibes all day. And so that was my favorite one I've had in a while. It was a lovely client. It felt good. That child is now something, it's probably 7, and is with his parents that he's been with his whole life, but now he gets to make it official. So,
out of my selfish curiosity, what was the issue on appeal for that particular case?
So the biological parent didn't want their rights to be terminated. And my understanding was, even though they never spent any time with this child since the child was something like 11 days old and had shown up at this adopting parent's house with cigarette burns and just horrible things. But the biological parent felt that it was important to fight the termination so that the child one day would grow up and know that the parent fought for them. So it was just a sad case in so many ways, because even when people do terrible things, sometimes they don't realize what they're doing is terrible and it's not done with ill intention. And so I think that's probably true of the biological parent. But ultimately, it was about, should the parent's rights have been terminated? Was the biological father, did he get adequate notice? There were a list of factors the court needs to consider. So it was about that. But ultimately, it went out on procedural default, which was good for many reasons. But it was just one of those feel-good moments that we don't always get to have on appeal, but we did in this one.
That's awesome. Rach, this has been a lot of fun. So I firmly believe that I have no business doing any sort of appellate work.
Now you love procedural defaults too.
I mean, we have one case on appeal right now that we tried in Texas, and I'm hopeful and optimistic we'll get a good result, but who knows?
Yes.
But I hope that if we ever work with you, it's because we're defending a great result and not because we are hoping to overturn a bad result. But this has been really a lot of fun. Thank you for joining us.
Rachel, you started with curiosity, and you said the minds of Court of Appeals judges, Supreme Court judges, is a curious mind.
Yes.
Well, speaking to you and what you're able to provide is to feed that curiosity. And you fed our minds with a lot of knowledge, and I'm sure for the listeners, because it's a topic that we don't know much about as trial attorneys because we're thinking about the trial. But the trial is only one phase of the battle. So thank you for arming the listeners with what they need to succeed beyond the trial. Thank you.
Thanks for having me. I love all things appeals and procedure and all of these kinds of questions. So call me anytime. I'm more than happy to help. And thank you again for having me.
It's a pleasure. Thanks, Rachel.
Thanks for listening to Courtroom Stories and Tactics by RVA Trial Lawyers. Hosted by Sharif Gray and Niall Abuzaki. Please subscribe and leave us a review on Apple Podcasts, Spotify, YouTube, or any major podcast platform. Together, we're building a tribe of trial lawyers to remind the world what human life is truly worth, one verdict at a time.